Prime Minister Julia Gillard says Premier KRISTINA Keneally is welching on a deal to harmonise national workplace safety laws. The Premier says New South Wales needs an exemption from those laws because it wants to deliver higher standards of workplace safety. The opposition has a conspiracy theory that the Keneally government is trying to go it alone to win the political and financial backing from the unions in a desperate bid to shore up its voter base before the March state election. But there's another story behind the workplace safety dispute. It's to do with the law and a recent High Court decision which used scathing language about the New South Wales way of prosecuting workplace safety. Shortly a studio debate, first Nick Grimm with some compelling case law.
Chief, come on. Come on. Come on, mate. Come on.
It's unbelievable to think that 8 years of your life that you're constantly worried about losing everything because of a prosecution for something you haven't done. Come on, mate.
Graham KIRK's battle with work cover began a decade ago when his friend and employee Graham Palmer was killed while working on his farm at Razorback near Picton on Sydney's southwestern outskirts. The farm manager's accidental death was as mystifying as it was tragic, but Graham KIRK was shocked further still when he discovered he was to be prosecuted for failing to provide a safe workplace.
I can understand if somebody had done something stupid or the equipment was faulty or there'd been some cause, but it was completely inexplicable. And it was a terrible, harrowing experience. We just had lunch together and we were just chatting and we walked.
Over the years, Graham KIRK has told and retold his story to safety inspectors, prosecuting lawyers and to the judges who heard his case. This week, he walked state line through his farm manager's movements on the day he died.
I walked out here with Graham. He got onto the bike here and rode off through the gate, and that was the last time I saw him alive.
The farm manager rode an agricultural quad bike down the steep tracks to the farm's back gully where he died. Along his way, Graham Palmer collected 6 steel pipes like these, which he began towing along the ground behind his bike.
He came down here with the bike with the steel behind it, and instead of following this road through here, he chose just to drop off the edge there and go straight down that
Quite steep.
Very, very steep. Very, very steep, very grassy. So there was no traction with the four-wheeler and the steel just slid on the grass instead of following the track, which has a better gradient. But still, nobody would have even taken the four-wheeler to start with when there were so many other vehicles available to them.
As was acknowledged in the court case, it was inexplicable why he decided to do that.
Totally inexplicable, yeah, for him to go down there and to take this silly little shortcut which cost him his life.
Graham KIRK was still grieving for his friend when he learned that under the New South Wales occupational health and safety regime, the law presumed him responsible for the death unless he could prove otherwise. Australian law is built on the premise of innocent until proven guilty, except that is in New South Wales, where a so-called reverse onus of proof applies to employers involved in workplace accidents. Prosecuted by the state's workplace safety watchdog, WorkCover, Graham KIRK received a criminal conviction in the state's Industrial Relations Commission.
I was extremely open with them and explained everything to them and showed them the situation, and I just thought it was a cursory, examination of the facts of the day. But they completely distorted the facts of the day and came up with some charge that I didn't maintain a safe workplace. And they could never specifically say what wasn't safe about it, because we showed them every element of safety, and what they were pinned their whole case on was that I didn't give adequate training for somebody to ride off a sheer cliff.
Well, it's almost impossible to defend a situation where you are presumed to be guilty and then have to go about proving yourself innocent when there has been a workplace accident.
Stephen Cartwright from the New South Wales Business Chamber says Graham KIRK has lived most employers' nightmare as a result of this state's occupational health and safety laws. But, determined to clear his name, Graham KIRK went to the High Court to challenge the legality of his conviction. He won, with the High Court finding he had received unjust, oppressive and absurd treatment and quashing his conviction.
When we were approached to assist with the funding of the appeal to the High Court, we were absolutely happy to do so because we felt that his case was almost a perfect example of what's wrong with the existing system in New South Wales.
I found it heartening that somebody listened to that, that they squashed my criminal conviction, and it gives people in business, especially farmers, some hope.
Graham KIRK's case also highlights why a public stoush has recently erupted between the Premier and the Prime Minister. Julia Gillard has warned the state risks losing $140 million in federal funding if it doesn't honour an agreement to introduce uniform national workplace safety laws. But KRISTINA KENEALLY is determined that New South Wales should remain the nation's only jurisdiction where the reverse onus of proof applies. She's also refusing to amend laws which give unions the power to launch prosecutions against employers involved in workplace accidents.
At every ministerial council meeting, at every juncture, the New South Wales Cabinet has taken the position that these two provisions, the reverse onus of proof and the union's right to prosecute, should be part of our occupational health and safety system going forward. That position has not changed.
Is your best strategy here to just wait 4 months, given the expectation that Barry O'Farrell will soon be the New South Wales Premier?
Well, I think my best strategy is to pursue, day after day, the delivery of the deal. A deal's been signed, a deal needs to be honoured. It's no more complicated than that.
Certainly Graham KIRK thinks the issue is pretty simple. After spending more than $1 million of his own money fighting to clear his name of a criminal conviction, he can't see any good reason why the law shouldn't be changed.
All the other states in Australia think it's a ridiculous law and that New South Wales stands alone on this. And you would have thought that KRISTINA KENEALLY would have seen reason, but she doesn't seem to be seeing any reason, and she doesn't seem to be listening to any argument that's being put about except from the unions and what appears to be the backroom boys in the Labor Party in New South Wales.